Hello everyone, and welcome to our sixth video tutorial on the topic of statutory interpretation. I wanted to start this video by just looking at an overview of the topic of statutory interpretation because it is quite a big topic. You can see here on this slide I've divided it into the three key areas that you need to know about. So as part of statutory interpretation, you need to know the approaches or the rules to stat. You need to be able to talk about the aids to statutory interpretation, and also you need to know the three rules of language. Now, in our previous 5 videos, we've looked at an introduction to statutory interpretation, the reasons why these rules are needed in the first place. In our second video, we looked at the literal rule. In our third, we looked at the golden rule. In our fourth, we looked at the mischief rule. And in our last video, number 5, we looked at the purpose of approach. So today what we're moving on to is looking at the aids to statutory interpretation. So when we're looking at the aids to interpretation, we're looking at things that, as well as the 4 main rules or the approaches, that judges actually have some other things that assist them, i.e. aids, that helps them to understand the meaning of a statute. So what we're going to be looking at today are the presumptions, internal or intrinsic aids to interpretation, and external or extrinsic aids to interpretation. So I'd like to start with the presumptions. And the presumptions are just the general rules, if you like, that the court always starts off with. They can be rebutted, but they are sort of the general rules for interpreting a statute. And the 4 key ones that you should be aware of are the ones that are on the slide for you here. So the first presumption is that statutes or acts of parliament don't change the common law. So what that means is any cases that we have, remember our cases are common law, so our cases still exist alongside statutes or acts of parliament unless that statute or act of parliament says otherwise. Another general rule or presumption is that the requirement for mens rea or the guilty mind in criminal law is required in criminal cases. And we know that already from looking at the case of Sweet and Parsley when we were looking at the topic of strict liability. And if you remember the principle in Sweet and Parsley, it is that there's a general presumption in criminal law that mens rea is required. And that's relating to this presumption here. Presumption here is that the Crown is not bound by any statute, and the last one, statutes do not apply retrospectively. And that means that a statute, the general presumption is that that only applies to subsequent conduct. It'd be wrong if an Act of Parliament was created today saying it was illegal to wear a red t-shirt, and then someone was thrown in prison for wearing a t-shirt that was red yesterday when that law wasn't in place at the time. So that's what it means by statutes do not apply retrospectively, they only apply from that point onwards. So they're the presumptions then. So the next aid to interpretation that you need to be aware of are the internal or intrinsic aids to interpretation. Now, it doesn't matter which word is used here. So in the exam, they might call it internal aids or they might call it intrinsic aids. It means exactly the same thing. And an internal or an intrinsic aid is something within the act or within the statute itself, which can be of some assistance to the judge in understanding and interpreting the act in question. So I've given you some examples here in red of internal or intrinsic aids. So the first one is the long title and the short title of the act. So this might seem obvious, but of course, if you think about a book, sometimes the name of the book gives you an indication as to what it's about. It's exactly the same with Acts of Parliament. So in RCN and DHSS, in that case, we looked at that when we were looking at the mischief rule. That was the case where the nurses were giving out the abortion pills in hospital. In that particular case, when the judge was interpreting the law, he also referred to the long and the short title of the Abortion Act from 1967. So, the Abortion Act long title is an act to amend and clarify the law relating to termination of pregnancy by registered medical practitioners. And the short title is the Abortion Act 1967. So, the reason he was looking at the long title in this case, if I refer back to it, it's to clarify the law relating to termination of pregnancy by registered medical practitioners. And if you remember studying that case when we were looking at the mischief rule, the words to be interpreted were registered medical practitioners. So the long title of the Act was acting as an aid to interpretation for the judge, because it was telling the judge what the Act was trying to do. So the long and the short title can be an aid. Some Acts of Parliament also have interpretation sections. So we've studied the Theft Act when we were looking at criminal law. And if you recall, sections 2 to 6 of the Theft Act explain various terms used in the offence of theft. So, for example, section 2 of the Theft Act tells us situations which are not dishonest. So obviously that helps the judge to understand the meaning of the word dishonesty. Section 10 of the Theft Act, for instance, gives a definition of the term weapon of offence as being any article that's been adapted to cause harm, basically. So the Act itself may have little sections, little definition sections that assist the judge also. And again, because they're within the Act, they are an internal or an intrinsic aid. Some Acts of Parliament also contain schedules. And as you can see there, they usually come at the end of a section and include more detail. So in our second year of the course, we're going to be looking at contract law. And one act that we study there is the Unfair Contract Terms Act. And within that act itself, if you turn to Schedule 2, the act gives a test for deciding whether a term in a contract is reasonable or not. So it helps the judge with a definition of reasonableness. Some Acts of Parliament also have marginal notes and headings, which may be of some assistance as well. And punctuation within the Act itself can also be an aid to interpretation. If you think back to our first tutorial on statutory interpretation, we looked at some sentences such as "let's eat mum," and the difference that a comma can make to the interpretation of that sentence. Well, in the case of Hanlon and the Law Society, Lord Lowry said that judges can use punctuation to an aid to interpreting an Act of Parliament. But as I'm sure you can imagine, even when a judge has looked at all of these internal or intrinsic aids that are within the Act itself, might not be clear still. So there are other things that may be of assistance that are not in the Act, but rather they are outside of the Act. So we're going to move on now to look at the external or extrinsic aids to interpretation. So here's some of the things, again, I've put them in red for you, some of the things that are outside of the Act that can be some of assistance to the judge. So firstly, a dictionary. And a case that we looked at in our very first video tutorial was DPP and Cheeseman. And I'm sure you all remember that case, the guy who was caught masturbating in a toilet. And if you recall, the judge in that case used a dictionary to find out the meaning of the word passenger, because the Act in that case was from 1847, and the meaning of the word passenger has changed since then. So we discovered in that case that passenger meant a pedestrian, whereas to us today, we would expect a passenger to be someone you take in the passenger seat of a car, for instance. So dictionaries can be really useful, and they're going to be most useful for judges who want to use the literal rule, because obviously the literal rule is looking at the plain, ordinary meaning of a word. So a dictionary can be of great assistance in finding what that meaning is. There's also an Act of Parliament, the Interpretation Act from 1978, and this Act of Parliament gives judges some general rules, if you like, about how certain words are used in Acts of Parliament. So it tells judges that if you see he in a statute or an Act of Parliament, that also includes she, singular includes plural, a person means corporations, etc. So it's giving the judge some further guidance. The judge might also choose to look at previous Acts of Parliament and choose to look at earlier case law. And doing that might be particularly useful if you're trying to use the mischief rule or the purposive approach. Because for the mischief rule, the judge always starts by thinking, what was the law before the act? So therefore, looking at previous Acts of Parliament can help to clarify, was it legal before or was it illegal? What is the situation that we're trying to achieve now? Equally, cases from before the Act of Parliament might also be of some assistance. So if you think back to criminal law, when we were studying unlawful act manslaughter and gross negligence manslaughter, judges were using cases from other areas of law to help them develop the law. So in the case of Stevenson, the judge in that case famously, Atkin, gave the neighbour principle, and that was all about finding who would owe a duty of care in negligence. Although that was a civil case, that case was used in criminal manslaughter in order to determine duty of care for gross negligence manslaughter. So even if it's from another area of law potentially, it can be of assistance to a judge in another area. We also have the Human Rights Act. So the Human Rights Act was introduced in 1998, and it was in order to bring our legislation in line with the European Convention on Human Rights. And judges, we know this from looking at parliamentary lawmaking, judges, I suppose we looked at it as a limit on sovereignty, because judges have to interpret any of our domestic legislation in accordance with the European Convention on Human Rights. And if they believe that our statutes or our Acts of Parliament are in conflict with that convention, they can make a declaration of incompatibility. So this Act is telling judges to interpret legislation in line with the convention rights, and as I've said, to make a declaration if it's incompatible. Final extrinsic aid for us to look at today is Hansard. And Hansard is the reports of parliamentary debates that led up to the passing of the Act of Parliament. And these reports can tell the judge what was in the minds of the MPs when they were passing the Act. And that might be really useful, again, for judges who are wanting to use the mischief or the purposive approach. Because if you can see what the MPs were saying when they were passing a piece of law, you get more of an insight into what their intention was, what the Act was trying to achieve. And Pepper and Hart, very important case for us here. This was the very first case which allowed judges to use Hansard, and it overruled a previous case of Davis and Johnson on that point. So we'll look at this again when we look at overruling. But in Pepper and Hart, they were clear that judges shouldn't be using Hansard willy-nilly. They should only be using it if the words in the Act are ambiguous, obscure, or lead to absurdity. And there has to be a clear statement in Hansard that would resolve that doubt. So those are the aids to interpretation. I suggest maybe cover up the answers here. This is a little bullet point plan for what will go into it. But you might get on exam 1 a question, explain the extrinsic aids to interpretation, or explain the intrinsic aids to interpretation for 5 marks. So it'd be worth testing your knowledge from this video, having a go at that one, or equally having a go at the one on intrinsic aids.